Welcome to the Family Law Frontline.
Welcome back to the Family Law Frontline with Fedor Kozlov. Fedor is the founding partner and chief litigator at the law office of Fedor Kozlov. With over a decade of experience in Illinois family law, he handles high-stakes cases involving custody, property division, domestic violence, and complex divorces. I'm Leanne Lyon, and today we're talking about how Illinois courts calculate and enforce spousal support and what really drives a judge's decision on what's fair. Hello, Fedor.
Hello, how are you today?
Wonderful. Fedor, when clients first ask about maintenance, what are they usually most concerned about? For example, the amount, the length, or whether they'll maybe have to pay at all?
I think all of the above. And maintenance is interesting subject for the Illinois and Illinois legislature. Historically, it was designed more for to protect women rights. Just because a woman, she's a biological mother to children who stays home most of the time, uh, raise children while the father is out there working, building his career, earning money, things of that nature. And then, if a breakup occurs and the father or the husband is no longer in the household, he can easily move on with his life, continue with his career, his earning income, things like that. And the mother, she usually would have a gap in her employment history, and she might need to start things from zero, or maybe it'll be even more difficult for her considering her skills, education, age, to start a new profession or get employed. And especially still when, even if she gets child support, uh, kids are still little, you still need to dress them up in the morning, bring them to school, bring them from school, prepare lunches.
Yeah.
And that's what uh, legislature had in mind when they came up in Illinois years ago, was this notion of maintenance. And of course, you asked a question about the amounts and the lengths. It's all very important because for if the family lives in the same household and now they have to sell a house, and the mother needs to, or the wife in this case, she needs to move on and rent a place. So she needs money to rent a place. Maybe she doesn't have any savings. Maybe she doesn't have a job. Maybe she only has a part-time job. So, and she doesn't have this history, credit history that any landlord would look into and would ask based on that for the security deposit, the amount of the security deposit. So the amount matters a lot. What also matters, of course, is the lengths, for how long usually a wife would get maintenance. It all depends on the length of the marriage, of course, but not only that. So it's not a strict formula, even though there is a formula, but it's not strict. So we look into her age, the age of children, if there are any children, her skills, her ability to speak English, if we have people coming from abroad, or her education. And based on that, sometimes, even though she might be eligible for 5, 7 years of maintenance, the court would still ask to come back and review in 2 or 3 years just to make sure that she is making efforts to get employed. So the maintenance is not designed for a person, not to look for a job. Maintenance is kind of temporary help from a former husband, usually to a wife, to get back on her feet.
So once the courts decide the support is warranted, how do judges calculate the amount and the duration under Illinois' current formula?
I'll take a quick step back. because in your question there is another question. You said that once the judges decide that the maintenance is warranted, that's the
Yeah.
first step that you have to make. This is very important. Majority of the clients that come into the office, they presume that they are entitled to get maintenance. This is absolutely not right, not correct. First, you have to prove on behalf of the person seeking maintenance that he or she is actually eligible to receive maintenance. What I mean by that is maintenance is from a person who's making a lot more money to pay the person who makes less amount of money or making no income at all. But if we have a couple, let's say she's making $500,000 a year and he's making $3 million a year, she might not be eligible for maintenance because the court might still decide that, well, you're not eligible just because he makes 6 times more than you do. You can still live the way you live without any help from another person.
Got it.
Maintenance is designed for a spouse to maintain the same way of life as she used to while being married. So this is very important to understand that you first have to be eligible for that. The courts will also look into things like, did you lose your job voluntarily? Or are you not employed because you don't want to be employed? So these are the factors the court would look into first of all. Of course, a wife with children, not with no education and with significant gap of employment, would be eligible for maintenance. Once you make this step, once you prove that she's eligible, then you make a decision. You need to calculate the amount of maintenance. And it has to be equitable, it has to be reasonable. With child support, courts more strict. You created a life, you're responsible for this life, so you have to pay. For maintenance, courts would look into things like how much money he or she have to pay to the spouse. There is a formula, and I have a little page with this formula. You take 33% of a payer's annual income. Payer is the person who pays maintenance. Minus 25% of the payee's net annual income, provided that this amount does not exceed 40% of the combined income. Now, these are a lot of numbers, but many websites, attorney websites, including our website, have this formula already imputed into the system, and you just put the numbers and you get the amount of maintenance you can be eligible for. Also, it depends on the length of the marriage. I'm not going to go through particulars of that, but just it would be fair to say if you married for 20 years, the maintenance, you're entitled to get maintenance until the end of life, I mean forever. If you married only for 5 years, the period of maintenance is going to be minimal. So it could be a year or so. So it all depends on the length of the marriage too, which is reasonable because if if a couple lives together for 30 years and he was always he was making money, he's a CEO of a big company, and the wife, she raised again kids, the kids are already adults, and you are over 50 years of age and all of a sudden he leaves you for whatever reason, the wife would be entitled to receive maintenance until the end of life. But again, it's not, even though we have a formula, this is, remember that Illinois is a guideline state. Guideline state means that this is something that where we start from, we begin from. Okay, so is there eligibility for maintenance? If yes, then how much? If a couple makes, let's say he's making $90,000, 90, and she's making 50, yes, he makes more, but is she entitled to maintenance? Maybe no. It all depends on the way of life that they lived. It depends also when people get divorced, besides maintenance, besides child support, they divide a lot of other things, such as debt, which plays a huge role, significant role there, and any other marital assets, such a house. If she keeps the house to herself, free of mortgage, maybe she's not receiving any maintenance because she gets the house, right? Or if she gets his 401k, or if he gets her 401k. So all these pieces, you can move them, you can negotiate. And remember, if you can come to some kind of resolution, if you can find a compromise, the court will not interfere. If you, between you two, can decide what's equitable and fair, you can make any decision you want. You can avoid paying maintenance by simply giving her, instead of 50% of your 401k, you can give her 75% of 401k. Or you can buy her out on the house so she gets more cash or he gets more cash. So it all depends.
Interesting. So then how do major life changes like a job loss, remarriage, maybe retirement affect an existing maintenance order?
Very good question. And I have a case that is pending right now here in Illinois in Lake County. Um, I represent a husband in that case. I was not his divorce attorney to begin with. So this is a couple that came from Moldova. They've been married for about 10 years. They have two kids, two daughters, and they had a home. She's employed as a part-time, I think she's a fitness instructor, and he is a truck driver. So, as a part of their MSA, marital settlement agreement, he agrees that she would stay in the house, and he would pay mortgage for the house, and such payment for the mortgage would constitute paying maintenance. So instead of paying her directly, he's paying for the mortgage, and she's not paying for the mortgage, and he's responsible for other things, such as association dues, and they pay 50-50 on the property tax. As long as she does not remarry or she does not have marriage-like relationship, and that's very important. Illinois used to be a fault state. So if you cheat, if you abuse alcohol or drugs or whatever, it could be grounds for divorce. Now it's all reconcilable differences. However, maintenance will be terminated when a former spouse starts living with another person in a marriage-like relationship or cohabitation. That excludes dating, and that's what most of the confusion occurs. So you can date anybody you want. You're a free person. You're no longer married to anyone. You can go on a date. A person can stay. You can have intimate relationship with this person, and the person can stay overnight. That does not constitute marriage-like relationship or cohabitation. To prove cohabitation, you need to prove that these people travel together, go out together. The people from the outside view this couple as a husband and wife, in other words. Purchase flight tickets together. If their kids go to the same events, or if he takes her kids or she takes his kids to school and things like that. So it has to be everyday routine. So in my case, I think, and the opposing counsel disagrees because we filed petition to terminate maintenance, and I represent the former husband, because in my mind that is they have a marriage-like relationship. He brings his children to her house. He stays overnight. He doesn't pay rent. They just travel to Disneyland, things of that nature. So it should look like the maintenance should be terminated, and it's fair to my client. Why would he have to pay maintenance when there is another person in her life that supports her? Of course, she doesn't agree with that, and it's all very, very. We're scheduled for a hearing now, and it's all factual. So it's going to be an evidentiary hearing based on the factors, based on the facts, based on their testimony, and things like that. But if I would be able to prove it, my client would not have to pay maintenance. Of course, if a person marries to somebody else, that's by definition terminates maintenance because now you have another husband or a different wife, so you have a different, completely different relationship. Question about losing the job. So you can, if a payor, the person who pays maintenance, loses the job, he has to prove that he lost his job not voluntarily, but because of something else. And it has to be some kind of serious circumstances. If he gets or she gets into a car accident and he's in the hospital and he cannot drive a truck anymore, for example, or something else happens, that'll be a circumstance that would allow you either terminate maintenance or pause maintenance for a period of time. The judge might require you, to apply for jobs, and then it happened during COVID a lot. A lot of people filed a petition to terminate maintenance based on the significant change in the circumstances because he or she got sick or ill, or the company closed down because of that. But after that, you still have to make efforts to find a job by Zoom, or based on your skills, maybe something else. Or uh, when the COVID restrictions were lifted, you can still go and find a job. So it has to. If you lose the job from the payor side, it cannot be voluntarily. It has to, something has to happen that is outside of your control. Now, for the payees, it really probably doesn't matter. What matters if he or she gets employed and start making more money, right? Or if they win, they got lucky and win a lottery ticket. So, but I never saw that happening. But if you get a job and this job pays you significant income, the other side can file petition and either decrease or completely terminate maintenance payments.
Well, as we're wrapping up here for today, if there's anyone out there that's preparing to negotiate or litigate maintenance, what documentation or financial records should they gather right now to strengthen their case?
I get a lot of questions like, I am thinking about filing for divorce. I'm not employed right now, but I have this offer of job. Should I get this offer? It's a very difficult question for me to answer. On one hand, if you get an offer of job, probably you should take it. But with the maintenance, we look back, but also we look at what's going on at this very moment. So if a person used to not work at all, she was staying at home for years and years, and now all of a sudden she gets this new job opportunity, it's a very difficult question. On one hand, if she gets this job, most likely she's not going to get maintenance, because maintenance is, like I said, it's a temporary relief for a person to get back on her feet. So if she's already on her feet, maybe she's not eligible for maintenance at all. I get these questions a lot and I really don't know how to answer them. It's up to the person because I cannot predict the future. And remember this, if you waive maintenance, you can never ask the court or any other court in the future to get it back. So if you decide to waive maintenance today during the time of your divorce and you lose your job tomorrow, you're not going to get maintenance and you're not going to get any income. So before you waive maintenance, you really have to think about it if you really want to waive the maintenance, because there's no modification. You can reserve child support, you can reserve many other things and come back to court and ask for money to be paid to you, but not about the maintenance. So this is one of the biggest questions people ask me. If she's ready to get a new job, should she get the job? Should she not get the job? It's really hard to say. At the same time, when you get paid maintenance, the court still might ask you to go and find a job. So there are really no documents for you to prepare before the divorce, but you should really consult with your lawyer if you need to waive maintenance. Like I said, if you waive it, you're done.
Got it. Well, that is it for today's episode of the Family Law Frontline. If you are facing questions about spousal support or maintenance, visit lawyer-il.com to connect with Fedor Kozlov and his team. Thanks for listening, and be sure to like, subscribe, and share this episode with somebody who might need it. Thank you, Fedor.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.